That bill is out. We also heard item number 15, SB 1229. There were some amendments that made it be pulled off of consent. I'll take a motion on that. We do have a motion and a second. Call the roll, please.
Stone.
Aye.
Stone, aye. Wagner. Wagner, aye. Alejo. Chow. Chu. Chu, aye. Gallagher. Garcia. Aye. Garcia, aye. Holden. Holden, aye. Mainshine. Ting. Gallagher, aye.
That bill is also out. Thank you, members. And I will note for the record that item number 6, SB 1065, has been pulled from the hearing at the author's request. So now let's move to item number 7, SB 1078. Senator Jackson.
Thank you. And this is my last bill for today, and I appreciate your consideration of SB 1078. While we know that arbitration is not the flashiest policy topic, it is one of the most important issues, actually, for the people of California. If you have a cell phone, if you have a parent in a nursing home, if you go to the doctor, if you have a job, you may very likely be controlled by an arbitration agreement. And many people have no idea of that fact. But as a result of what have been some real concerns, the Senate Judiciary Committee, which I chair, held a hearing in March where we heard some very compelling stories from Californians about how powerless they felt going through an actual arbitration proceeding. We heard from an active military member. We heard from a small business owner. We heard about an abusive and largely unregulated system that stacks the deck against the elderly and the terminally ill. When you begin to compare arbitrations to public court proceedings, the private arbitration system, frankly, looks a little bit like anarchy in the justice system. Rules of evidence don't have to be followed. Discovery is limited. Arbitrators don't even have to follow the law. This doesn't sound like justice, at least to me. So I understand the reality of case law, the fact that the U.S. Supreme Court has disfavored attempts to limit arbitration agreements. I hope that at some point they'll reconsider that. I hope that that attitude will change. But until then, we have a moral obligation, I believe, that our arbitration system is as fair as possible. And this measure, SB 1078, I believe helps tip the scales of justice towards fairness. In this bill, I get at the repeat player problem. This is where a company brings the same arbitrator repeat business worth hundreds of thousands of dollars, if not millions of dollars, going forward. If you're the little guy or gal going up against the company, you're going to think there's no way you're going to get a fair shake after all. And when you look at the context of arbitration, this is a business for our arbitrators. This is a business. So, and I have nothing against business, and I have nothing against arbitrators. I know some of them. They're extremely competent, ethical human beings. But they're in business. And for them, the way they get business is to make sure that they have cases to determine. And if a company offers the opportunity to hear 100 of their cases, an example would be like a company like Sears, where there are frequently disputes. This is a judge that knows he or she is going to get this kind of repeat business. If not in actuality, it certainly can and does present the appearance to that little guy or woman out there that the system is rigged against them. And my bill says that the arbitrator cannot entertain or accept additional work from one of the parties to the arbitration while that arbitration is pending, unless both parties agree that it's okay for the arbitrator to take additional work from the party before any solicitation of the arbitrator takes place. I also get at a common practice by an arbitration provider organization. These providers put on seminars about how to win an arbitration, and they reach out to specific businesses to convince them to hire their arbitrators for future arbitrations. These practices, I believe, should not be allowed. Right now, they don't even have to be disclosed. So if you hold a seminar out to the general public, I think that's terrific. What's happening, though, is that they're offering them to specific law firms how to win an arbitration. Well, they might as well say how to win an arbitration before me, which creates an unlevel playing field. So This bill also stops arbitration providers from soliciting business in such a manner from a company that is a party to a pending arbitration using one of the provider's arbitrators. On this, members, I want to be clear. Arbitrators cannot do the same activity under existing ethical standards. This stops arbitration providers from stepping into the shoes of their arbitrators and doing the same prohibited activity. In other words, the company itself cannot or should not, I believe, be able to do what their actual arbitrators are not allowed to do. They should not be able to step into their shoes. Finally, my bill gets at the issue of accountability. There are rules that arbitrators are supposed to follow to ensure neutrality and fairness, but there is no accountability. If the arbitrator violates the ethical rules or fails to disclose, there are no consequences. At best, the consumer or employee can seek to vacate the award and begin the process all over again. And the arbitrator gets to keep all the money that they had earned. But the person in the arbitration, have to start over again and essentially pay twice. This just doesn't seem fair. It's an unjust enrichment if an arbitration has been vacated because of the behavior of the arbitrator. They still get to pocket the money, and you have to start all over again as the participant. I will refrain from those items unless I must at the end if there are questions. And this, I think, is an important issue, and I want to stress I have the highest regard for so many of the arbitrators who do this work. I know them personally, and they are above reproach. It is the system at this point that I think needs, based upon the hearings we've had, based upon testimony from a variety of people, the system needs some tweaking and some to be confined so that the public supports it, the public believes in it, that it has the credibility, and we don't see the public yet again feeling like all the justice, all the proper behaviors, all the proper decisions that are being made behind closed doors and for the benefit of those who have the most. With that, I respectfully ask for your aye vote, and will turn to my witness in support, Cliff Pilevsky, a partner with McGuinn, Hilsman and Pilevsky, and a member of both the California Employment Lawyers Association and the Consumer Attorneys of California, who are both in support of this bill.
Thank you. First witness.
Thank you very much. Just as a preliminary statement, I love ADR. I believe I have an ethical obligation to resolve cases even without filing. I do employment law. This is a pro-ADR bill. No justice system can succeed without the confidence of its users. And in order to have the confidence of its users and to fulfill its purpose, ADR has to be fair in fact and perception, the same as the courts. Avoiding the appearance of impropriety is just as important as avoiding improprieties. This bill is critical. It does not in any way limit arbitration, prohibit arbitration, interfere with any of the Supreme Court decisions on arbitration. Its goal is to make arbitration fairer and to improve its perception and the reality. As many of you know, the New York Times did a major three-part series exposing some of the problems that we're talking about now, including the repeat user player problem. We have a situation where there have been two cases that I'm aware of this year alone where during the pendency of an arbitration, an arbitrator took, in one case, 30 additional cases, and in another case, 40 additional cases from the same firm or party. And you can only imagine what it feels like to be the plaintiff in that case, knowing that the arbitrator has basically turned that company into a client. This bill does not prohibit arbitrators from taking additional cases, but it requires the consent of the party in the pending case. It's a very appropriate piece of legislation to ensure the perception of fairness. Unfortunately, it shouldn't be necessary, but the arbitration providers themselves have not implemented any limitations or restrictions to deal with this. So what this bill tries to do is to say, look, before you go and offer hundreds of thousands of dollars or $50,000 in new business to the arbitrator, get the permission of your opponent. It's a very reasonable approach. And I think that we have largely the support of CDRC on this because I think it is so obviously the right thing to do to avoid the appearance. You couldn't imagine a judge sitting on your case being offered money, lots of money, by one of the parties. This is an obvious ethical issue that needs to be taken care of. The disclosure part of this bill is critically important. Let me explain the role of the provider. The provider makes the rules, how the arbitration is going to proceed. They select the larger panel of the arbitrators. They rule on challenges for cause. And there's times when they actually even appoint the arbitrator. The provider can determine the outcome of the arbitration. Not every organization providing arbitrations is the American Arbitration Association or JAMS. The National Arbitration Forum has been prohibited from doing business in California because of their marketing and their conflicts of interest. There was an organization called the Patient Protective Association, which was formed by medical malpractice insurers, and doctors had to send their clients to those providers. So it's critical that the providers themselves recognize their obligation to be neutral, not only in the administration of cases, but in the marketing, because it's the marketing where the appearance of conflict arises. Some examples of things that have happened.
So I'm going to need you to wrap up.
Okay. Providers have sent representatives to firms and did file reviews, literally looked through the files of insurance companies and recommended arbitrators. As Senator Jackson said, they go into firms or companies and say, how do you succeed? And then they sit on those same cases. These kinds of conflicts, we're not prohibiting anything. It simply says you must disclose it the same way you disclose economic conflicts, personal conflicts, and prior cases.
Thank you. Next witness, please.
Yes. Good morning, Mr. Chair and members. My name is Elise Sanguinetti. I'm the president of the Consumer Attorneys of California, and I'm here today in support of SB 1078. As Senator Jackson and Mr. Palevsky just mentioned, this bill is focused on addressing the unfairness and bias in consumer arbitration, and we urge a strong aye vote in favor of this bill.
Thank you. Anyone else in support?
Mariko Yoshihara with the California Employment Lawyers Association in support.
Thank you. Anyone else in support? Seeing none, is there opposition? Could you make room? Thank you.
Hey, Bob.
Good morning. My name is Paul Dubois, and I'm the...
Use the microphone, please.
I'm sorry. My name is Paul Dubois, and I'm the legislative chair of the CDRC. And I want to say at the outset, I do appreciate the efforts of Senator Jackson's staff to amend the bill, though we are not yet satisfied with it. I also appreciate her kind words about arbitrators. The part of the bill that concerns an arbitrator reappearing in cases is not a major problem for us. We think it needs some tweaking, which I put forth in my letter of June 14th, so I won't discuss that today. What I'm concerned about is the section which requires an arbitrator to refund fees if a motion to vacate is granted. Now, whether you support this bill or oppose it, the fact is the bill has many flaws in it and goes beyond the idea of transparency that Senator Jackson seeks. And I have 8 different points I want to discuss. First of all, the bill destroys arbitrator immunity. Every other state and all the federal courts allow for arbitrator immunity. If this bill passes, California will be the only state that does not have arbitrator immunity. Second, even though I think the idea of the bill is, I don't know what happened here. Well, I'll go without it. I think the idea, can you hear? The idea of the bill is concerning lack of disclosure. The bill goes way beyond that. And basically, an arbitrator will be liable to refund the fees in any motion to vacate that is successful, except where the motion to vacate is for exceeding powers or postponing a failure to postpone a hearing. Third, and this is very important, the bill may very well be unconstitutional. Although the arbitrator now has the right to appear and be heard at a hearing on a motion to vacate, the arbitrator is still not a party to that hearing. So if the court decides to assess the arbitrator with the fees, the arbitrator can't appeal. He or she is not a party. So basically, you have, under the bill, you'll have a court assessing liability to a person who is neither a party to the case and has no right of appeal. And that is unfair. The bill also allows all parties to recover fees. So a party who loses, a corporation that loses the motion to vacate still can recover the fees from the arbitrator. If an arbitration has 3 arbitrators and 1 arbitrator fails to disclose, all 3 arbitrators have to refund the money, even though the 2 of them didn't do anything wrong.
So I'm going to need you to wrap up.
What's that?
I'm going to need you to wrap up.
Okay, I got 3 more points very quickly. An arbitrator is liable for failing to disclose what the provider has for meetings. Arbitrators don't know what the provider does. They have no idea. They can't disclose something they don't know about. And finally, the bill absolves an arbitrator for harmless error. But harmless error is not a ground for vacatur, so I don't know what that harmless error section does. So I think the bill needs reworking, and the CDRC therefore opposes it.
Thank you. Next witness, please.
Thank you, Mr. Chairman, members of the committee. Hal Dassinger with the Civil Justice Association of California. We're opposed to the bill because it will limit the ability of arbitration companies and arbitrators to function and making arbitration less useful as an alternative means of resolving disputes more cheaply and more quickly than available in the civil court system. Some companies have dozens or hundreds of neutrals, any one of whom could be performing arbitration services at any given time. Some of them will be providing services as neutrals to companies that are repeat users of arbitration. This bill would act as a ban on those companies marketing to their most frequent users. That's a practical barrier. Some neutrals will be providing services for parties that are frequent users of arbitration, and they will be unable to schedule future work during the pendency of that arbitration, which could be a day or 2 or a week or a month or 6 months. That's a practical barrier that makes it very difficult for the arbitration to function. Current law requires extensive disclosure about the prior history between an arbitrator and the parties, and we think that that covers the disclosure requirements adequately. Current law also requires arbitrators to abide by rules set forth by the Judicial Council regarding their ethical behavior, provides for vacatur of an award if there's an ethical breach. And your prior witness mentioned there was at least one company banned from arbitrating in California because of their marketing practices. We believe the system is working. Ask for your no vote. Thank you.
Thank you. Anyone else in opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Mr. Gallagher?
I think one thing I'm struggling with here is, I don't know that we can say on the one hand that we think that arbitrators are upright and doing a good job, and then on the one hand this bill kind of questions that and says, well, no, you're going to make decisions based on whether or not your arbitration company is getting business from people. And I think, I think we agree that arbitrators don't do that, that they're neutrals, and that they do make decisions based on the case before them, and just like a judge does in court. And a judge sees repeat litigators. The same attorneys are often coming into that courtroom, but regardless of the fact that they see these attorneys on a daily basis and very similar cases over and over again, they're going to make the decision based on that particular case and what they believe is the right outcome. And I think arbitrators do the same thing.
There is one difference. I'm sorry.
Yeah, go ahead.
There is one difference. The judges are there from 8:30 to who knows what hour of the night, regardless of who is prosecuting or defending a case in their courtroom. Arbitrators are there. They sit based on who pays for them for their time. It's the motivation is different. And while I do, as I mentioned, I have very high regard for most arbitrators. There are there are some questions and there is some perception, there is some reality where it appears that justice has not been served. And even though that happens in a courtroom where a judge is a state employee or is paid a regular check every month, no matter what he or she does, no matter how he or she rules, arbitrators are not. And the perception, while people sometimes feel that justice isn't done in our state courtrooms, in our county courtrooms, there is, I think, very rarely a claim that they've been bought off. I guess you can claim anything. But when it comes to an arbitration, when you are paid by the arbitration and by the clients who come to you for the purpose of your deciding their case, you've added an element that does, by its very nature, I think, cause concerns. And that's what we're trying to do here, is we're trying to address the concerns of perception and, in some cases, reality. Arbitrators are not required to follow the law. In many instances, they aren't required to give you a written decision for the way they rule, so that you have no basis for understanding why they have ruled the way they have. Whereas in a court, under the rules that we have for our actual judiciary system, there are very stringent rules. Here, we can, an arbitrator can suspend the rules of evidence or discovery. I mean, there are reasons that this happens. Sometimes they make perfectly good sense. But it is a system and a structure that we are trying to essentially make more transparent, more fair to the parties, particularly the ones that don't have repeat business, and to make the system, I think, meet the measure of what the public expects in its judicial process, whether it's because we force arbitrations on them or whether we don't. And in so many instances, as I said in my opening remarks, where if you buy a cell phone, you have agreed to arbitrate any disputes you have. That's the way it goes. The Supreme Court said that's the way it goes. And so if that's going to be the law, or until that is changed, at least we've got to make the system more fair and more equitable, both in fact and in perception.
Thank you. Any other further questions, comments? Senator, I'd like to thank you for bringing this forward. I appreciate it.
And with that, I close. Thank you.
Thank you. I think take that as your close. And I appreciate the distinction here. And as we talk about, I mean, lawyers have obligations about advertising and not advertising and all. And it seems that in this realm, it's gone a lot further than we would expect within the legal profession. And to me, that's one of the things essentially that you're addressing in your bill. And I appreciate that you brought that forward.
Thank you.
All right.
Ask for your
So
iPhone.
looking for a motion. The motion is due pass. We have a motion and a second. Call the roll.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Alejo, aye. Chow? Chu? Chu, aye. Gallagher? Garcia? Aye. Garcia, aye. Holden? Mainshine? Ting? It needs one more.
Excuse me, the bill is on call. And
Thank you.
we will take it up when we get the rest of the members here.
Thank you, Mr. Chair and members. Appreciate your consideration.
Thank you. Next, we have Senator Monning.
Mr. Morrell will go ahead of me, and I'll go after Mr.
Okay, Senator Morrell. And as he's coming up, we do have a proposed consent agenda. Unless someone would like to move someone, there's been a motion and a second. Call the roll.
Stone?
Aye.
Stone, aye. Wagner? Aye. Wagner, aye. Alejo? Aye. Alejo, aye. Chow? Chu? Gallagher? Aye. Gallagher, aye. Garcia? Garcia, aye. Holden? Mainshine? Ting?
That is also going to be held on call. That is item number 12, SB 820 Hertzberg. Item number 13, SB 942 Liu. Item number 14, SB 944, which is a bill of the Transportation and Housing Committee. And item number 16, SB 1406, Senator Mendoza. All right, Senator Morrell, you have item number 3, SB 983.
Wow. Good morning, Mr. Chair
morning.
members. Sorry about that. This is SB 983, which it really is simple change. It's had no opposition. It's a change to California Civil Code relating to trustees who handle non-judicial foreclosures on behalf of lenders. The bill proposes a very modest increase to the statutory caps on fees which may be charged by trustees facilitating this process. It has not been increased in 15 years, and the $50 increase proposed in the bill is approximately half the rate of inflation since the last increase back in 2001. So anyway, on behalf of me is Lexi from the United Trustees Association to answer any questions you may have, and I would respectfully request an aye vote. Thank you.
Thank you. First witness, please.
Mr. Chair and members, Lexi Howard with California Advocates on behalf of the United Trustees Association. This fee has not been increased since 2002. It is half the increase in CPI since that time. Trustees have taken on additional duties in that time, primarily related to their additional notifications and requirements under the Homeowners Bill of Rights. Here to answer any questions and respectfully ask for your aye vote.
Thank you. Anyone else in support? Seeing none, is there any opposition? Seeing none, questions from the committee? Do you have a motion and a second? Senator Morrell, you may close.
No, thank you for listening and for your time. And again, I would appreciate an aye vote. Thank you.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Alejo? Aye. Alejo, aye. Chow? Chu? Gallagher? Garcia? Aye. Garcia, aye. Holden? Mainshine? Ting.
Thank you.
All right, we will put that bill on call.
Thank you.
Thank you. Since everyone seems to have left. Senator Monning. And we are going to hear item number 8, SB 1092.
That's correct. Thank you, Mr. Chair. And just for the record, we are postponing, with your support, SB 1065 to next week. We're continuing to work with some of the stakeholders on amendments. So appreciate your indulgence on that. And members, SB 1092 requires short-term home sharing companies who operate through an internet hosting platform to provide a disclosure to homeowners or tenants listing their property about the need to review their insurance coverage to ensure they are covered in the event of injury or damage during the rental period. Many homeowners and renters list their residences for short-term rental on internet hosting platforms such as Airbnb, HomeAway, and Vacation Rentals by Owner. Unfortunately, many are unaware of the insurance ramifications if damage to property or injury at the property occurs during the rental period. Most current homeowners insurance policies allow some period of limited commercial use, but the terms can vary significantly based on the insurance company. If the activity is explicitly excluded by the policy, the homeowner or tenant may be liable for injuries or property loss. It is important for homeowners and renters who make their properties available through these internet hosting platforms to understand that their insurance coverage and whether it will protect them. SB 1092 simply requires these websites to provide a notice to the homeowner or renter to review their insurance coverage before listing their property. Members, I'd ask for your aye vote at the appropriate time and would ask the chair if I could present witnesses in support.
Absolutely. First witness.
Thank you.
Good morning, Mr. Chair and members of the committee. Armand Feliciano on behalf of the Association of California Insurance Companies. We support SB 1092. As reflected in the analysis, existing law does require hosting platforms to notify their hosts to check their lease, and this bill builds on that by asking or requiring hosting platforms to notify their hosts to check their insurance. We think it's a good consumer protection bill. More broadly, from a public policy standpoint, we believe homeowners and renters should know up front about the insurance coverage prior to participating in such activities. Thank you.
Thank you. Additional.
Good morning. Sherry McHugh, representing the Pacific Association of Domestic Insurance Companies. We are in strong support of SB 1092. It is truly a simple disclosure bill to make sure that people check their insurance coverage to ensure they are properly insured prior to putting their homes on a hosting platform. Thank you.
Thank you. Ms. Borg.
Catherine Borg with the Western Manufactured Housing Communities. The bill also adds mobile homes as the in the list of homes that people should look at their leases before they decide to do this.
All right. Thank you. Additional witnesses in support. Just going to use the microphone.
Morning, Mr. Chair and members. Dwight Koo, representing CSA Insurance Group, a AAA insurer. We are in support of the bill.
Thank you. Witnesses in opposition? Seeing none, questions or comments from the committee? Bill has been moved and seconded. Seeing no comments, Senator, you may close.
I respectfully ask for your aye vote. Thank you.
Thank you. Call the roll, please.
Stone, Wagner.
Aye.
Wagner, aye. Alejo. Alejo, aye. Chow. Chu. Gallagher. Garcia. Garcia, aye. Holden, Mainshine, Ting.
All right. That bill will be on call. Thank you, Senator.
Thank you, members.
Do we have any other senators in the House? All right. If there are staffs of any authors out there monitoring, we are looking for authors. Senator Hueso, Senator Wachowski, Senator Leno. Mr. Chu, I saw in the hallway. You've got a bill if you want to come present. All right. In the meantime, let's lift the call and take some add-ons. Senator Wachowski's in the House. Let's go ahead and lift the call and take some add-ons real quick.
SB 983, votes 3-0. Wagner.
Aye.
Wagner, aye. Chow. Chu. Gallagher. Holden, Mainshine, Ting.